Today, I'm at the Child Rights Center of Akaki Tsereteli State University in Kutaisi. And the subject of today is the historical evolution of child rights. We read the Convention on the Rights of the Child, adopted on 20 November 1989, and we don't necessarily understand how much work and how much struggle it took to reach this level. In fact, in 1919, when the League of Nations established a committee for children, they called it the Children's Welfare Committee, because at that time, child rights as a term was not used. In 1919, in the UK, a lady called Eglantine Jebb started advocating for children's rights. And she was saying that children need to be protected, especially that women and children were the ones that were most affected by the harms of World War I. And Eglantine Jebb was able, by 1923, to gather support for a declaration on the rights of the child, which entailed of 5 items. And the same declaration was adopted in 1924 by the League of Nations. But declarations are always non-binding, and they only express a political willingness of the states to implement them. That's why the need for a convention, for a mandatory convention after ratification, was very much needed. After 1924, in 1946, the drafting of the Universal Declaration of Human Rights started. But 1946 to 1948 witnessed a lot of conflict between the Western Bloc and the Eastern Bloc. The Western Bloc considering that human rights should be civil and political rights, and the Eastern Bloc considering that human rights are economic, social, and cultural rights. And that led to the fact that instead of having a convention on human rights, we got a declaration on human rights, non-binding, and on 10 December 1948, member states of the United Nations voted by raising hands. Fortunately, later on, the Universal Declaration of Human Rights was considered as part of international customary law, and thus is considered right now as mandatory not only to states and governments, but to any group of people, to any population, everywhere. But for children, the Universal Declaration of Human Rights was not enough, although it covers all the rights of human beings, but there was still a need to have special documents for children. We should not forget that the Universal Declaration of Human Rights considered that women and children have the right to special care and special assistance during emergencies. At the same time, the Universal Declaration of Human Rights recognized the right to social protection of children born out of wedlock. Having said this, there were many other rights for women and for children which needed to be further developed, and that's why we got in 1979 the CEDAW Convention, the Convention on the Elimination of All Forms of Discrimination against Women, and 10 years later, in 1989, we got the Convention on the Rights of the Child. Having said this, the efforts continued after 1945, starting from 1945, when the United Nations Organization was established, and in 1959, the UN General Assembly adopted a declaration on the rights of the child, another declaration, a second declaration after the 1924 one, and it contained 10 articles. And these articles, although they were focused on protection, but also they mentioned some developmental rights of children. And the slogan of the 1959 Declaration was, mankind should give to children the best it has. It is also worth mentioning that the 1959 Declaration on the Rights of the Child was adopted on 20 November. And the UN Convention on the Rights of the Child of 1989 was also adopted on 20 November, which has become the International Children's Day. Between 1959 and 1989, there was a year which was very important for children. That was 1979. Because Poland suggested in 1976 to have a year dedicated for children and for child rights. And the UN General Assembly decided to have 1979. And since 1979, the culture of child-centered statistics and national reports on the situation of children started. But also 1979 was very important for children because the United Nations established a working group to draft the Convention on the Rights of the Child. And from 1979 to 1989, 10 years of drafting, which were characterized mainly by the participation of NGOs, of religious denominations, of children themselves, and young people. That's why one of the drafters of the convention said, when you read the Convention on the Rights of the Child, the CRC, you can hear the voices of children. Because there was a high level of participation from all stakeholders and children themselves in the drafting of the convention. And by adopting the convention by the United Nations General Assembly, children have been recognized as a person of international law. Because before the CEDAW as well, women were not having the full recognition in international law as a social category which deserves having a special treaty. And children, the same. Their protection was considered, provided through the family. And even in many instances, they used to say that when the family is fine, the child is fine. But when the concept of the best interest of the child emerged, then we started thinking that there are instances when the family may not be respecting the best interest of the child. And that's why, in this case, there should be an intervention to fix the situation and to make sure that every child has all the rights and her or his best interest is respected. The main power of the Convention on the Rights of the Child is its philosophy revolving around achieving the best interest of the child. And the four general principles that were recognized by the UN Committee on the Rights of the Child in 1990, that time of 10 members, and then the number was increased to 18 members. So the four general principles are: 1, non-discrimination, which we can find in Article 2 of the Convention; the best interest of the child, which we can find in Article 3; the right to life, survival, and development, which we can find in Article 6; and the right to participation, which is in Article 12, and which is basically the respect for the views of the child in Article 12, and then the right to empowerment through respecting the right to freedom of thought in Article 13, freedom of conscience and religion in Article 14, freedom of assembly in Article 15, freedom and the right to privacy in Article 17, and the right to information in Article 17, which includes also the right of children to be protected from harmful information. So Articles 13 to Articles 13 to 17, combined with Article 12, deliver the right to participation. Because if participation is not combined with empowerment, then it will never be meaningful. And that's the huge difference between granting the rights and empowering the individual to be able to exercise the rights. And the sequence from Article 12 to Article 17 explains very well how children should be empowered, not only to have the right theoretically, but also to be able to exercise the right. And this is how the language of rights turn out from being a literature to becoming a practical tool to implement children's rights at legal level, but at social level as well. And this is the strength of legislations in every country where they adopt the general principles of the UN Convention on the Rights of the Child. They also adopt and integrate all the provisions of the convention, and the judges start applying these rights practically in the courts to grant children their rights. Lawyers start defending children based on the Convention on the Rights of the Child. Social workers prepare their social inquiry reports with a child rights-based approach. Teachers educate children with a child rights-based approach. They become child rights-based educators. And this is how the culture of child rights is promoted into society, and it leads to a sustainable development, because SDGs will never be implemented fully if we don't start investing properly in children's rights. And this is how democracies become stronger, and this is how children enjoy their rights, and they can all the time be sure that they have a legal system protecting them and effective tools, be able to use them anytime if the rights are violated and whenever the rights are violated.